In the previous videos, we have discussed quite a breadth and depth regarding the nominated subcontractor. The relevant information can be found under Clause 27 of the PAM contract 2018. We mentioned about the relationship between the contractor, employer, and the nominated subcontractor. We have established that the relationship is between the employer and the contractor, and there will be another relationship. It is between the contractors and the nominated subcontractor. Under the definitions of the contract, the employer has no direct relationship with the nominated subcontractor. This is on the basis that the nominated subcontractor is actually subcontracting the works from the contractor. For the work ultimately to be delivered to the employer, taking this as an example, it will be the work A, B, C, and D. For the claim that the contractor can be made from the employer, it shall also cover the work A, B, C, and D. Only that the work D here is done by the nominated subcontractor. Since the relationship is between the contractors and the nominated subcontractor, the nominated subcontractor should be able to claim for the work that has been done from the contractor. With that, we can consider that the nominated subcontractor is under the responsibility of the contractor. This is so because first, the works to be delivered to the employer by the contractor shall cover all the works, and it is most likely that this work D here is to be incorporated into the overall project here, so that the entire system here fit the purpose. Talking about this fitting the purpose here, the contractor has the obligations to ensure the entire project here fit to the purpose before being delivered to the employer. As far as the nominated subcontractor concerned, the NSC will need to ensure the work D here fit to the purpose when it is delivered to the contractor. Because of this relationship, the responsibility, the payments and claim will have to be separated. To further understand these situations, we may refer to the scenario 1 here. This was the scenario that we have discussed and introduced at the early stage of the module here. Some questions has been posted here, which may seem awkward if we don't fully understand the contract. Now that we have come to Clause 27, the things becomes clearer. A brief recall from the scenarios that we have discussed previously. If you wish to know more, you may go back and search for the relevant videos. Now in this case here, we have an employer awarding a project to a contractor. The employer engaged the architect as the contract administrator. At the same time, the company also nominated a subcontractor, and this nominated subcontractor, it will be under the responsibility of the contractor. Now the problem occurs when the nominated subcontractor is unable to deliver the work on time, and the nominated subcontractor is seeking excuse for the extension of time. You know that in order for the extension of time to be reasonably applied, there must be a valid reason. It should be due to any of these relevant events, as well as the relevant event listed here. In the case here, the delay is due to the negligence of the nominated subcontractor. He is seeking excuse for the extension of time. Of course, it is not under the relevant event. and therefore the applications of the extension of time shall be rejected. In this scenario there, the work has obviously been delayed, and the contractor here was not charged any penalty. Instead, the contractor is given extension of time so that the work can be completed nicely. And because of the negligence of the nominated subcontractor, the extension of time is not given to the nominated subcontractor. As a result, the contractor can charge the liquidated damage from the nominated subcontractor. This is about the scenario here. Now, during our discussions previously regarding this scenario, we are asking, is this legally possible? Is this right? It seems that the contractor is the ultimate winner. The employers not getting the project on time, no penalty being charged onto the contractor. Instead, the contractor is given extension of time. Penalty is charged onto the nominated subcontractor, and no extension of time is given to the nominated subcontractor. Now that you have already understood the basis of the PAM contract, you know all this is possible. To further explain this, let us look at this slide here. We have the relationship between the employer and the contractor. The contract is between the employer and the contractor. We have another relationship. It is between the contractor and the nominated subcontractor. So there should be a contract between these two parties. Now the architect here will be the administrator for the contract to ensure that everyone within the loop here plays their role and deliver their obligations. Now let us talk about the responsibility of all these parties. The employer will need to finance the project. That means for whichever work done by the contractor and the nominated subcontractor, payment should be made. And this payment should be made within a specific durations. Otherwise, the employer shall be considered default. Now the contractor here take charge of the contract works. Those works has been specifically outlined under the contract. The requirements and specifications are also clearly stated. The contractor will need to finish the work on time up to the quality as required by the contract. Otherwise, the contractor will be considered default. Now, the nominated subcontractor is taking charge on the subcontracting work under the contract works of the contractor. The contractor have the responsibility over the nominated subcontractor. The nominated subcontractor will need to deliver the subcontracting work on time and as per the requirements and quality as stated in the contract. Failing to do so, the nominated subcontractor will be considered default. In terms of the payment received from, the contractor will receive payment from the employer. So the payment received from the employer. As for the nominated subcontractor, the payment is received from the contractor. Now the amount being paid, as far as what is received from the contractor, it will be for the entire project. This includes the contract work as well as the subcontract work. The contract work, it will be under the portions of the contractor, and this subcontract work later will need to be paid to the nominated subcontractor. And as far as what is reaching the nominated subcontractor, it will be the subcontracting work. Here, the contract works portions has already been taken by the contractor. Now let us look at various possible cases here. This is as an extension to further explain the situation here. For this scenario, we disregard the issue on the rookie here. This was raised in the previous videos to demonstrate the scenario better. Now when we want to analyze this, we simplify the situations, focusing the relationship between the main parties here. Now under the normal case here, when the nominated subcontractor is able to deliver his part of the work on time, and at the same time the contractor also able to deliver his part of work on time also. Now the entire project here can be delivered on time to the employer. With that, the employer will need to make full payment to the contractor. That means the amount paid, it will be for the contract work plus the subcontracting work to the contractor. Since the nominated subcontractors also deliver the work on time, full payment should be made by the contractors to the nominated subcontractor for the subcontracting work that has been done by the nominated subcontractor. This is the normal case and everything runs smoothly. Everyone is happy. The employer is happy, contractor is happy, nominated subcontractor is also happy. Now what if the nominated subcontractor delay his part? This will be the same scenario here, when the nominated subcontractor cannot deliver on time. The delay here is referring to without valid reason. That means no EOT shall be granted in the case of delay. So what's happening here is the nominated subcontractor delay the work, but at the same time the contractors deliver his part of the work on time, excluding the part delayed by the nominated subcontractor. As a result, whatever ultimately delivered to the contractor, it will be the main contract part on time, but the subcontract parts not on time. In terms of the payment, the employer will need to pay partially to the contractor. The meaning of partial payment here is referring to the payment up to the extent of the work that has been properly executed. If we need to break down this, the contractor will receive full payment due to all the works done by the contractor has been on time. The partial payment received by the contractor, it will be the full for the contract work but partial for the subcontract work. This results in the partial payment. Because now the problem is due to the nominated subcontractor, the contractor is not being penalized. The extension of time is awarded to the contractor. Since the contractor cannot deliver the full project here back to the employer, there should be liquidated damage incurred or loss and expenses as a result of the delay. This is so far between the relationship between the employer and the contractor. Now when come to the relationship between the contractor and the nominated subcontractor, the nominated subcontractor shall be entitled with partial payment. The payment only made for the work that has been properly done. The remaining work shall not be given any payment. As a result of the delay, there shall be liquidated damage to be charged onto the nominated subcontractor by the contractor. This may also involve other causes in terms of the loss and expenses due to the delay. Now, whichever losses experienced by the employer will be charged to the contractor, and this amount of charges shall be transferred to the nominated subcontractor. At the end of the day, the contractor is not being charged any penalties, and the extension of time is given to the contractor, but the contractor will charge the nominated subcontractor, and no extension of time is given. This is exactly what is happening under the scenario 1 here. Let's say now both the contractors and the nominated subcontractor delay their work without valid reasons. We have both the contractor delay and the nominated subcontractor delay also. Now both the contractors and the nominated subcontractor will be paid partially. The payments only cover for the work that has been completed. The remaining work shall be charged with the liquidated damages. Under these circumstances, both the contractors and the nominated subcontractors are not entitled with the extension of time, because now the problems due to both parties here. As far as the employer is concerned, employer paid partially to the contractor and charged liquidated damage as well as the other losses to the contractor. Then the contractor may also charge onto the nominated subcontractor for the liquidated damage and only pay the nominated subcontractor for whichever work that has been done by the nominated subcontractor. Since the contractors also delay the part on the main contract here, the contractor cannot transfer all the liability to the nominated subcontractor. Whichever scope done by the contractors and the nominated subcontractor should be quite clear-cut. Next, let us look at the case where the contractors delay only, and this is without the valid reason. In this case, the nominated subcontractor delivered the work on time. As a result, the nominated subcontractor shall be paid fully. No liquidated damage should be charged onto the nominated subcontractor. Now the delay is due to the contractor here. The payment by the employer will be partial to the contractor. It will be full for the subcontracting work, as later this need to be paid fully to the nominated subcontractor. But now the contracting part, it will be partial for whichever work that has already been done by the contractor. Now that the contractor is unable to deliver the entire work to the employer, there shall be liquidated damage incurred. If you see the model here, the payments and the liquidated damage has been made quite objective. Whoever is the cause of the problem should come with the consequences. It is only that you can prove the problem doesn't come from you, then you should be able to receive full payment, and in the case of delay incurred, you shall be granted with the extension of time. Now coming back to the scenario here, remember previously we mentioned about the descriptions of the relevant project. One of the characteristics of the project here is due to the tight schedule. It was stated that EOT will not be allowed. To be more specific, it should mean that the employer here do not wish to have the extension of time, as this is going to result in the losses as a result of the delay. Now, if you look to the clause 23 regarding the extension of time, there is no such thing as the EOC is not allowed. To be more precise, we can say that the employer cannot prevent the EOT if the cause of the delay is due to the valid reason. The valid reasons will have to be one of the relevant events listed here and also listed here. If the reason is valid, whether the employer like it or dislike it, EOT will have to be granted. Therefore, the statement about the EOT not allowed here, it shall be on the basis that there is no reasonable reasons or no ground to apply for the EOT. I feel this is also important to highlight this, that the employer cannot reject all the applications of the EOT even with reasonable reason.